thank you for having us. I'm glad that we had a chance to get a presentation put together over what I think is going to be one of the craziest roller coaster rides in the Minnesota State statutes and law over the next, maybe even over the next decade. What we are going to present today is the state of medical cannabis in Minnesota and possibly where this is headed. So for those of you who don't know me already, I'm Brandan Borgos, and I'm joined by Maren Schroeder. And we are on the board of a nonprofit together, Sensible Minnesota. We formed this nonprofit earlier this year. And as a little bit of a background to that, just as so for those of you who may not have voted for me last year, you can't go back in time with the DeLorean. It's not going to help. But I ran for Attorney General last year on the Independence Party ticket, and in the process of doing that, and also having the background of being the board chair of Minnesota NORML, the Minnesota branch of the National Organization for the Reform of Marijuana Laws for the last couple of years, I ran into some patients that were helping lobby for the medical cannabis bill down at the state legislature. I was heavily involved in those efforts. In the process of that, there was a woman in southwestern Minnesota, and you may have seen her in the news. Her name is Angela Brown. Now, how many of you know this story, just by show of hands? Does anybody know Angela Brown's story? Okay. So, in the state of Minnesota, there's no necessity defense to using cannabis as a medicine in court. So if you're caught, you can't say, I did it because I was helping someone, helping my son, or I would do this. That's not allowed in the court. So in Madison, Minnesota, Angela's 11-year-old son be caught.
By the way.
What's that?
Madison, Minnesota is my hometown.
Oh, really? Wow. Well, do you know Angela? It's very small.
I don't personally, but I know people who know her.
Okay. Yeah, she's in my opinion, a wonderful mother, a wonderful person, and she has a few children. One of their names is Trey. He actually caught a line drive baseball to the head when he was playing baseball. I think he was 11, 12 years old. He was put into the hospital, had a decent amount of brain tissue damage, and he was hospitalized for quite a while. When he got out of the hospital and was finally better, he started getting seizures, severe chronic pain, and he began self-harming. And his school grades dropped very, very rapidly. He wasn't doing very well. So Angela then found some links on the internet and found out about medical cannabis and the treatment of seizures and the treatment of intractable. Started administering cannabis oil to her son, and lo and behold, he started to get much better, and he was doing better in school. He was much better behaved, and during a parent-teacher conference, the question was asked of her, what were they doing differently, because he was doing so much better in school. Well, lo and behold, she tells them that, of course, she'd been giving her son cannabis oil. So, being mandatory reporters, they report her to Child Protective Services, and Child Protective Services do not want to touch this case at all. So they back away with their hands up. But the county prosecutor, however, had it's definitely out for her. So he charged her with 2 counts of child endangerment, and proceeded with prosecution of Angela Brown for that. With the rest of the candidates from several other of the parties, I organized I think 27 political candidates over the 2014 election season, and we all signed on to a petition to get these charges dropped. That political pressure combined with very good lawyering by my friend Michael Hughes, and threats from the prosecutor to get Trey to testify against his mother, resulted in a lot of negative publicity for them. They have since dropped the charges, and she is now moving out of the state of Minnesota to Colorado with her son. So that thankfully was taken care of in a manner I thought that didn't necessarily need to happen. Now, how that plays in with our medical cannabis law right now is that we we are seeing a lot of patients possibly going to be running into the same sort of issues. On the basis of the fact that they're not necessarily going to qualify for this. This is not like other states' cannabis laws. It's the second most restrictive law in the United States. And that being, I think, Georgia being the first based on a legal difference in making doctors prescribe it, because you cannot prescribe this. That is the DEA's wheelhouse. They'll yank your license to practice medicine. So if you have questions for us along the way, I invite those. Please save those till the end, or give me a raised eyebrow if you happen to think that we're talking malarkey. I'm sure that Maren will be more than happy to point out any inaccuracies I happen to push across.
I'm here because Brandan's a lawyer and he can't take care of himself. And I was given permission to rip on him through the whole presentation, so I'm going to do my best. Brandan told his story about how he got involved in advocacy. I'm going to tell mine just briefly because he took way too much time. Lawyers talk a lot, right? So my mom is actually one of 41 certified patients in Minnesota. She has both MS and glaucoma. She's been certified. We'll talk a little bit later about her story. But I got into the advocacy to help her. She received some oil from Colorado about 2 years ago, and all her inflammation went down. She could go for walks again. Her pressures were down in her eyes and had remarkable results. So when this came into the legislature, I got we're going for it, and now she's one of the first 50 patients in the program. So that's a little bit of my background. I just finished my MBA in legal administration, and we're going to be working for Brandan. Congratulations. Thank you. Did I miss anything I was supposed to talk about?
Well, other than the fact that she helped organize this presentation, she also helped organize my own thought process and try to get a law firm put together. So I did start a law firm fresh out of law school in 2010 with, let's say, mixed results, because maybe lawyers don't make the best business people if they're trying to do 4 jobs at once. So in the process of Maren doing her MBA, she's helped me define the boundaries of a business plan for a law firm that she spent 6 months working on. So we hope to be opening next month, along with a lot of these issues that overlap currently with the cannabis program. So that being the basic background to us, to understand how we got to where we are in Minnesota, before we even start talking about the law in Minnesota, you kind of have to have a good background in where we've been, understanding that this is really coming full circle. We do have a few slides here on the history of cannabis prohibition in the actual entire United States. It goes much further back than this in time as far as medical cannabis use is concerned. It's been documented in 3,000-year-old texts in Asia, and up until the early 1800s, cannabis was actually used as medicine in the United States, much for pain, menstrual cramps, things of that nature. It was put into small tinctures. And we didn't see a lot of changing of the laws along the federal level initially. In the early 1900s, there were laws going state by state banning marijuana, which is, everybody knows this is the name for cannabis. But it was the name that a lot of these state legislatures decided to attribute to cannabis because there were Mexicans coming across the border that they wouldn't necessarily want in the southern states. So some of those states started passing those laws pretty rapidly. The 1800s saw also states regulating cannabis under these poison control acts, and this was one of the very first ways that states decided to start regulating medicine and doctors because of, everybody's heard of snake oil, I'm assuming. Snake oil actually is helpful for some people, but it turns out that some people were selling things that actually wasn't snake oil. So states saw fit to regulate these substances. So we're going to fast forward through a lot of the time between 1908 up until the 1930. And if we remember alcohol prohibition, that was in the full vogue in the 20s. And in fact, the Volstead Act came from a guy named Volstead who grew up in Minnesota. So we are maybe the home of prohibition. I don't maybe want to tack that onto the list of things we've accomplished, though. So. The Volstead Act, absolute failure, but the federal government ramped up this massive army of federal agents, and now they had nothing to do anymore when alcohol prohibition was lifted. So, of course, like all good bureaucracies, they found something else to go after, which also was very, very helpful for a couple of other industries, namely the paper industry, and to some extent the pharmaceutical industry as well. So there is a name, William Randolph Hearst. Hearst Paper Manufacturing owned the majority of the timber land in the entire United States. And they also owned a lot of the publications that were going around. And if you've heard the term yellow journalism, these guys were great at it. I won't go into detail on what they were pushing across too much because that's beyond the scope of what we're talking about today. But needless to say, the 1937 Marijuana Tax Act was really the brainchild of these people and my favorite person who I love to hate from the past, Harry Anslinger. Now, Harry Anslinger was the head of the Federal Bureau of Narcotics. He came into the Senate Ways and Means Committee testifying before, who then would become later Chief Justice Fred Vinson of the United States Supreme Court, saying that cannabis was the most dangerous violence-causing drug known to mankind. And they also consulted the AMA. They learned about it 2 days before the floor vote. So a doctor named Dr. Woodward of the American Medical Association showed up, and he had testified before Congress on this exact same issue back in 1914 when they had pushed the Harrison Narcotics Act, and he wanted to make sure that this wasn't going to just be an outright ban. What the 37 Tax Act did was tax cannabis hemp to the point where farmers and also doctors would no longer be able to prescribe or get the substance out because the taxes were so prohibitive it would essentially ban the substance. The biggest problem with this is that Schroeder said to them, no, the AMA does not support this. This is medicine. You can't ban this outright. And 2 days later, there were two questions asked on the floor of the legislature. One, what is marijuana? The answer being it's a narcotic of some kind, I think. And two, what did the AMA say about it? And then Representative Vinson stood up and said, oh, the AMA, Dr. Wharton is totally for this, thus fudging his name. I feel you, Dr. Wharton. People are not pronouncing my name ever correctly. So they passed it with a voice vote, and they were able to do so because there was no constitutional provision for the Commerce Clause for them to regulate and just ban the substance entirely, which is what they did, and Wickard v. Filburn later on. But that case itself was a farmer growing wheat, and the court deciding that the wheat that he kept for himself was also taxable, and in that way they could reach into any state doing anything, even if something hadn't passed into other states or inserted itself into interstate commerce. So we go blazing past 1938. Cannabis is now a dangerous drug, of course, causing murders and rampant violence everywhere. Not a lot of users back then under this prohibition. Not a lot of people knew about it. We did have hemp also completely banned at the time until 42 or 43, where people were required to grow it for the federal government for the war effort. 1951 Boggs Act threw out mandatory minimum sentences, and then of course we have the 1970 Controlled Substance Act by our wonderful President Nixon. So Nixon also did decide to get a commission together on whether or not he should further legalize cannabis. And the commission came back on marijuana as a government commission. They said, no, this shouldn't be criminalized. it's probably better as medicine, don't do that. Well, Nixon kind of shrugged the report and just moved forward. And then, of course, finally, 1973, we have the creation of the DEA.
Okay, so I'm going to talk a little bit about the Controlled Substances Act. Is anyone here familiar with the Controlled Substances Act? Kind of? Okay. So there's 5 schedules. We're going to talk about Schedule 1 and Schedule 2. Schedule 1 drugs have no medicinal use. They are at the highest risk for abuse. And they are banned. There's super big hurdles for research on them. Schedule 1 includes hallucinogens, date rape drugs, heroin, and marijuana. And then we look at Schedule 2, which doctors can prescribe. And we have cocaine and meth and morphine and all that nasty stuff. So what we've seen with the federal government is the biggest issue with marijuana being in Schedule 1 is there's no research. If there's no research, we can't call it safe. There's a doctor at the University of Arizona, Dr. Sue Sicily. And I just kind of want to give you guys an idea of the bureaucracy surrounding this. In 2011, she decided that she wanted to do a cannabis study with PTSD patients. Many of you heard of Dr. Sicily? Okay, cool. So Dr. Sicily applies to the DEA. Thank you. I have to fact check every once in a while. Applies to the DEA for the study. The DEA says, great. Well, then there's this next step where she has to get approval from the U.S. Public Health Service. Now, marijuana is the only drug in Schedule 1 that required approval from the U.S. Public Health Service. This requirement was removed like Monday. The Obama administration got it out of there. But it only applied to marijuana. Now, Sicily waited 3 years for approval from the United States Public Health Service to do her study on patients with PTSD. She finally got approval in 2014. She now has to get the product from the National Institute on Drug Abuse. They are the only organization in the United States blessed by the federal government to grow marijuana. They do that at the University of Mississippi. She's been waiting and is still waiting 15 months to get her product to perform her study that she started in 2011. Once she has the product from NIDA, then she has to go back to the DEA to get a Schedule 1 license. So we're talking years to get any research done here. So essentially in Schedule 1, it's illegal to use, possess, dispense, manufacture marijuana, period, under federal law.
So that kind of brings us to this case, which harkens back a little bit to poor farmer Filburn. And in the federal courts, of course, 1996 was the first time cannabis legalization for medical use was passed. And this happened, I believe it was Prop 19 out in California in 96. So we've had quite a few years between then and now to maybe get these things straightened out. Along the way, of course, there is this interplay between the federal government and state government because the laws don't actually match up. Now, Ms. Rach was growing cannabis for her own medical use in accordance with state law. And these cases have come up quite often, actually. The federal government goes in, they grab a bunch of crops, they burn them all, they put people in jail, and people keep doing it. But she was the first person to successfully challenge us along the court path to get it up to the Supreme Court and ask the question whether or not what she was doing was legal because it's legal under state law. The question, I guess, does kind of harken back to that Wickard versus Filburn case because the federal government had then used the Commerce Clause to go ahead and reach into the state commerce that wasn't really affecting any other state. So they were relying on the idea that that the federal government can interject itself into state activities. In this case, nothing, there was no charges of her distributing it or anything like that other to any other states. How many people think that she won that case? Good, you've all been paying attention. All right. So, obviously, federal government was right according to the Supreme Court here. So Gonzalez v. Rake was really this idea that the federal system, the supremacy clause, and including also the interstate commerce clause, allows the federal government to go in and prosecute medical cannabis patients even if they're acting underneath state law legally. So that creates this situation that we're still finding ourselves in right now, and including with some of the regulations that the Minnesota Department of Health and our legislature maybe didn't have the foresight to look into, is probably cause for a lot of doctors and patients not wanting to sign up because they have to provide their DEA license when they go on the Minnesota Department of Health website. The reality here is, of course, that most cannabis arrests actually happen at the state level. It's not like the feds are coming in. They'll do that when there's grow ops. Fun little tidbit on the side note is that the Obama administration had, even with their guidance on some of these memos that Maren will talk about in a second here, arrested, and it had more raids underneath that administration than under the Bush administration. So it's a very, very weird interplay of what's going on here, and that might actually have to do with the DEA administrative head, Michelle Leonhardt, who is no longer the DEA head due to some sex scandals and things like that. Sorry. Anyway. You can look that up yourself.
Okay, so I'm gonna hold my iPad while I do this because I actually have to read part of this, which is terrible. I should memorize it, but I haven't yet. So how do states get away with this? Brandan mentioned executive orders. Obama and former Attorney General Holder issued a series of executive orders. They're listed up here. They'll be on your flash drive. The first one, Ogden. Simple, told prosecutors, these are low priority, leave them alone. Then we have the Cole memos. There's 3 of them. The first Cole memo says, if you deal with cannabis money, you can be prosecuted for money laundering. And that put a stop on all banking, putting all cannabis businesses into cash. So you go into Colorado, you go into California, Washington, safes full of cash. There's a really great show on CNN and High Profits, and it shows them literally having to take suitcases of cash to the state capitol to pay their taxes. So that's where we're sitting with that. The second Cole memo, and this is where I need to read, it laid forth 8 priorities. It's a big list, that's why I gotta read it. The first was preventing distribution of cannabis to minors. The second was preventing revenue from going to criminal enterprises, gangs, and cartels. The third was preventing diversion from a state where it's legal to a state where it's not. Next was preventing state-authorized activity as a cover or pretext for trafficking or other illegal activity. The prevention of violence and the use of firearms in the grow and distribution. Preventing drug driving and the exacerbation of negative public health effects. Preventing the growing of cannabis on public lands. And preventing cannabis possession or use on federal property. Now, after Cole 2 came out, banks kind of were like, well, those are the priorities, money laundering isn't important anymore, and Cole 3 says, you can still be prosecuted for money laundering, but prosecutors should use their discretion and try to apply it to these 8 priorities laid forth in the second Cole memo. So, we have a little bit of guidance from the federal government there, but like Brandan said, there's been more raids under the Obama administration than there was under the Bush administration. So how effective these are, I don't know. The last one, Wilkinson, came out in the fall of 2014 that directs U.S. district attorneys to confer with their local tribal governments regarding reservations and growing growing and operating on reservations with cannabis. And Red Lake is actually in the works of putting together a personal use program right now. So,
as is some South Dakota tribes.
yeah, so that is happening now.
So I have a question.
Go ahead.
So, is the whole cannabis thing because of the Schedule 1 designation? Like if I brew a craft beer at home, can drink and get drunk, that's fine. I'm not hurting anybody, I'm just brewing craft beer.
Well, it
There's
depends on
nothing
how it tastes. I
illegal.
mean, if it's terrible, you might. But I get your point. I get your point.
But if I grow,
Up to
and if I
50
make,
gallons a person or something, whatever.
There's
if I
regulations
make
and limitations.
I make heroin and use it myself, I'm not for anybody else, not just my own home use. Heroin would be illegal to make and use myself. And in the same way with cannabis or marijuana, it's because of that Schedule 1, it's illegal to grow and use myself. That's all I guess.
Right, and there are a number of other subsidiary and tangential statutes that make it illegal to drive with, have a firearm with, operate cars.
Anything like I'm not selling, I'm not driving.
If you have a kid and you have your house, you can
Right.
do child endangerment. Oh,
Okay,
sorry.
yeah, so there's
Child
some
endangerment.
other crime or some other law or statute to break you.
Right.
So it's just making it and using it for your own.
And Schedule 1 does track with Minnesota state schedules. And actually, one of our board members, Curtis Hanna, went after the Board of Pharmacy once, and this is relevant to this slide, once he realized this was this many states that had cannabis as a medicine, like as a legal argument. And to that effect, he wanted to make the argument that because Schedule 1 says you have it clearly outlined that there's no accepted medical use in the United States, and even the DEA's own federal administrative judge, Francis Young, has said this is the most safe, therapeutically active substance known to man. DEA threw that out, they just decided not to look at that. But given that, you, Minnesota Board of Pharmacy, should make a determination on whether cannabis is medicine and get back to the state legislature on this. Well, there was some shuffling there, some papers and a little bit of bureaucracy, and then during the Controlled Substance Omnibus Bill, the state legislature removed the Board of Pharmacy's ability to review any substances in Schedule 1, but they could add whatever they wanted to it. They weren't able no longer to review those at all, thus ponying it up to the legislature. So they kind of kicked that can out a little bit down the road to avoid answering, and what I think was Curtis's question to them. So we get into this situation where people have, in a lot of these states, home grow. So they're able to grow a whole plant in their basement. They pick it from a variety of strains, and they have these cannabis clubs that they speak amongst each other to find out what works for them, what doesn't, because different kinds will have different effects on different people. We've heard of maybe Charlotte's Web here at all. So Charlotte's Web is a CBD only strain. There is low levels of THC, and that does CBD is cannabidiol, and then of course THC is tetrahydrocannabidiol. So two different substances. But CBD actually gets rid of seizures almost entirely. We'll talk about that in a few minutes here, but they're able to pick and choose. Minnesota, you can't do that. There's no whole plant, there's no smoking, there's no buds anywhere. It's liquid pill form, and nothing smokable. Basically, what we're looking at in our state, in addition to a lot of these other states, is a highly regulated market in which there are only a few qualifying conditions that actually have any overlap with a lot of these other states. Minnesota's law was a combination of a very, very well thought, drawn out law, piece of law that was put together by people who had looked at how well the other laws work in the other states, namely Arizona, which operated under a very good regulatory system, distribution system with, I think, approximately 55 different dispensaries across the state, all being operated under state law, state regulation, and each one of those dispensaries catering to a number of different ailments that wasn't so tightly controlled as ours. That's something that our state's not having. Just a few blocks down the road here, we have one of our manufacturers, Minnesota Medical, and they're over on Thursday. They're going to be opening next Wednesday, actually. So they'll be one of 8 distribution sites, and we'll get into that in a little bit too.
Yeah, you just took half my next slide away from me, so thank you.
She'll probably fill in all the gaps I missed.
Yeah, I'm going to
because
dovetail back to what Brandan
oversight's not
forgot on this map. So this map you'll have in here on your,
Thanks.
yeah, no problem. So this map, I just want to clarify, do you guys know what decriminalized means? Absolutely not. Okay, cool. So decriminalization is kind of, so we have medical, we have recreational, and we have decriminalization. Minnesota is a decriminalized state, so you can, do you think you can walk down the street with an ounce of marijuana in your pocket without going to jail?
Yes.
Yeah. In Minnesota, under 42.5 grams of marijuana is a petty misdemeanor, it's a civil fine, there's no jail time attached to it. Now, if you put it in a car, around a child, around a gun, you're talking a totally different thing. But general possession is simply a civil fine, and that we're starting to see spread throughout the country.
Delaware is also
Yes.
one of them. Actually, this is something that passed in Delaware, and close to Delaware, of course, is Washington, D.C. This is one of the things that, because Delaware wasn't added to this for decriminalization, it's so tiny you can't see it up in there. But D.C. actually legalized recreational cannabis use. But since it's illegal on federal lands, there's these maps on the internet where you have to kind of like watch what streets you're walking on. Because if you step over here, you're a federal felon. But if you're over here, you're basically okay. So it's interesting too that we have a lot of our, well, basically Amy Klobuchar and Al Franken maybe out there and in Rome.
You know, buy and sell. Is it legal to buy and sell?
In Washington, D.C.?
No, Minnesota.
No.
So you can possess.
You can possess,
amount,
but they don't tell you how you can get that amount, and you can't grow it. Growing is a whole other story. You
Oh,
can
yeah, that's
possess,
very bad.
yes.
Don't.
Don't grow your
Don't brew your own cannabis. It doesn't matter what taste. You'll be hurting yourself. Well, the government will come to hurt you.
You know, I know you're getting ideas there, Terry. Okay, so I'm going to move this along and go into Minnesota's medical. So as Brandan mentioned, there is only oil, pill, vapor forms. There is no whole plant, and there is no smokable form. The extraction process that the manufacturers are using is a whole plant extraction process, so they do pull all of the cannabinoids out of the plant and put them into the oil. How they do that, I'm not a scientist, so I have no idea, but that's what they're doing. In Minnesota, we only have 9 qualifying conditions. The first being cancer with severe chronic pain, nausea, vomiting.
Cachexia.
Thank you. I'm going to do that both times I have to say that word. And severe wasting. The second being glaucoma, third HIV/AIDS, Tourette syndrome, ALS or Lou Gehrig's disease, ice bucket challenge, seizures, including those characteristic of epilepsy, and this is what you've probably seen on the news with the children with Dravet syndrome. So they've been through a whole myriad of Schedule 2, Schedule 3 medications, pharmaceuticals, synthetics that haven't worked, or the side effects have been so severe that the children couldn't function. Well, they're finding that this CBD, high CBD concentrate is reducing or eliminating the seizures altogether. Now, that's not true for every child with seizures, but that's where you're seeing it, especially with the children. And then we have Crohn's disease. We have severe and persistent muscle spasms, including those characteristic of MS. That is where my mom is qualified. And I did talk to her, and she said, go ahead, tell everyone, tell the world. So
You're not violating HIPAA, right?
yeah. Yeah, so, yeah, as long as I have her permission, I guess. And then terminal illnesses, your life expectancy has to be under 1 year, and it has to accompany with the same symptoms as cancer.
Very terminal illness. You can't have cancer light, you have to have cancer with terminal illness or one of these other conditions.
So then, go ahead.
So, how did they come up with this list if there's no research?
Oh, that's so fun.
That's its own
It seems
whole-
discriminatory.
Yeah, I'd love to answer that question in an hour-long conversation. It was a very crazy political process.
Let me-
And it's largely anecdotal evidence, it's because they're not allowed to do research.
Yeah.
Right.
So it's like, okay, I heard this works, works for your mom, her glaucoma.
Right.
There you go.
So I'm going to spit out a little bit about adding conditions here,
Yeah.
which might help kind of answer that question, maybe, won't answer it, but a little more guidance on it. So the first big debate when they were choosing conditions was intractable pain. You hear that a lot when it comes to medical cannabis. So written into the actual statute was that the Commissioner of Health needed to make a recommendation to the legislature on adding intractable pain by July 1st of 2016. The Commissioner formed a task force. They've been having public meetings. Their next one is in September. And they've said that they're going to make a decision by January 1st. Following a decision on intractable pain, the Commissioner can hold hearings and make recommendations on other illnesses. So PTSD is the one I think of off the top of my head because that's kind of the buzz in the news right now. And how that happens is the Commissioner holds the public hearings, holds the meetings, hears testimony from doctors, hears testimony from patients, and then makes a recommendation by January 15th. If the legislature then has that next session to act, to approve or deny, if they take no action, it automatically adds as of August 1st. So we should see, probably not in 2016, but in 2017, we should see this list grow. How much? I don't know. I don't have the answer for that.
And there could be additions to these specific conditions as well, expanding, say, the first to incorporate any cancer if they deem that necessary. So those sorts of things can happen at the administrative level. And kind of in the same vein of your question, the initial bill was thought to support anywhere from 55,000 to 90,000 people, given the addition of intractable pain, all forms of cancer without these other things that happen when it's maybe starting to get a little too late, like help, and also PTSD. But that is now narrowed, and these two companies are trying to serve a state with an approximate 5,000 patients total between the two of them. So there are going to be some pretty hefty bills for them that they will have to pay in cash for.
Would it be temporary? Like, could you use it for, you're going through chemo? And then.
That would be the idea. Yeah.
Yeah. So, how do you become a patient? This is where I'm gonna kind of go into a little bit of my personal experience with this because June 1st was when patients could become certified. That was when doctors could start certifying patients. So my mom has 2 of the 9 qualifying conditions. It's helped her in the past, so we want to get her into the program. Now she starts by calling her glaucoma doctor, because that's the easiest thing to do. I have glaucoma, certify me. No glaucoma doctors at that provider are certifying patients. This becomes a repetitive thing. The doctor's not certifying, the healthcare facility doesn't have a policy, so doctors aren't certifying, there's not enough research, whatever the excuse may be. We're 3.5 weeks in with 41 patients registered. So what we did with my mom, that first step, that contact healthcare practitioner, and the second step, the wait, that is the time consumption right there. That is the biggest part of this whole thing. So with my mom, we tried again with her MS. I went with her to the appointment and was able to talk to the doctor. Well, there's no research for this. Well, part of Minnesota's law, step number 5, when the patient goes to refill their cannabis supply, they fill out a self-evaluation form. So, and then they have to see their practitioner on a regular basis, and that practitioner then is required to make reports to the Department of Health. So we're collecting data on the patients in the program to perform the research. And I think this is pretty unique to Minnesota.
Yeah, I don't think that there's a lot of states that require the entire handing over of medical records of patients to the state government. That's an issue in a lot of other situations, but I believe that Minnesota is the only one that does that. I can check up on that.
Is it mandatory that you have to give your?
Yes,
So
it is
that might be
mandatory
a
for both
huge
providers
hesitation.
and patients.
Unless you buy it from Jose on the corner.
Which,
I don't know, Jose.
Some politicians may have recommended that last year, not
Yes.
naming.
So she got approved. We went to the doctor, I talked to the doctor, explained the research component of the law, directed him to the MDH website, showed him which link to click, and he went through the whole form and certified her right there on the spot. So what happened then was we went home. The patient has to register then. My mom with MS has some cognitive issues, so the doctor did certify her to have a caregiver and named me as the caregiver. So not only now does my mom have to go through registration, I have to go through registration. So we got her registered, and it took about 2 weeks for that to be approved. I submitted my caregiver application on the same day, but as a caregiver, I have to go through a BCA background check, which is 4 to 6 weeks out. So when she goes for her first appointment on July 1st to get the medicine, I can't go with her unless my background check is back. So she's going in completely blind, no idea what she's doing, and I think we're gonna see that with some of the patients as well. The cannabis patient centers, we have 2 manufacturers in Minnesota. We have MinMed, Minnesota Medical Solutions, excuse me, shorten that down, and Leafline Labs. MinMed manufactures in Otsego, Leafline in Cottage Grove. Minnesota Medical Solutions will have, the only dispensary they will have open on July 1st is the one in downtown Minneapolis. Brandon's at about 3 blocks away. And then Leafline Labs will open theirs July 1st in Eagan. So, and then there's, each manufacturer gets 3 more throughout the state. And I'll use my cheat sheet here. Minnesota Medical has Rochester, and they're expected to open late July. So for my mom, that's awesome, because we're down there Rochester. And then they will have Moorhead and Eden Prairie. And then Leafline Labs will have their center in Eagan, as well as St. Cloud, St. Paul, and Hibbing. As far as the manufacturers and their requirements for security, they're incredible. Personal identification systems, full security systems, intrusion detection, the whole gamut of secure this as much as possible, and that's both for the manufacturing facility and for the dispensing facility.
As well as transportation
Yeah.
regulations that look a lot like nuclear waste and nuclear armaments regulations. Do not take the same route twice. No, it has to be randomized. Don't want, people jumping in with their Mad Max type style vigilante cannabis liberation movements.
So, this is kind of the unknown now, is they visit the center. And what's gonna happen there is they're going to meet likely with a pharmacist who specializes in cannabinoids and their mixtures, and try to find the right combination for the patient. So that's part of the self-reporting, that's part of the doctor's reporting, is do we need to raise the cannabidiol, do we need to raise the THC levels, do we need to raise the CBN? There's a whole bunch of different factors taken into account there. Cost. Estimates are coming out at $300 to $500 a month, for some patients twice that. So it's become very cost prohibitive for a lot of our patients, which is, I'm hoping personally from some of the numbers I've seen, I'm hoping like for my mom who needs very little, her price is gonna be closer to $100, $150 a month, but the average is $300 to $500. Lori?
you know
What
what?
what is the response from like medical insurance companies?
No coverage.
Absolutely not.
Absolutely not.
I
What about your
have-
HSA?
Oh, right.
Can't swipe the card.
Yeah,
You pay
I
cash and reimburse, and hopefully they don't audit you.
I have thankfully contacted some of the larger medical insurance providers like Blue Cross Blue Shield. They don't have a written policy about cannabis. They don't obviously pay for it, but my main concern was if a patient's using this and a different medication or something like that, is that reason for you to yank health insurance? And get an answer on that, so that might be an issue that you might see people staring at down the road.
I would think that they would get up to speed. I mean, you know, if these patients are certified for this medication, insurance should be covering it.
Not until federal law changes.
Right. They don't want to
Right,
touch
because
it.
Yeah, we
in
did
violation
research
of
at
federal
my
law.
employer about it, and nobody wants to touch it because the law is still developing, and it's a lot of risk. Insurers don't want to touch it.
So here's the fun part. I'm gonna move us along because Brandon talks a lot and took way too much time at the beginning of this, and I don't want to.
Just check that. It's right. We don't have.
Yeah, so I talked about being a caregiver already, going through the BCA background check. My name, my date of birth will be on every package dispatched to my mom. I can then transport it, possess it without being convicted of a felony for doing so. And then along with that, also a rule change that didn't make it into our wonderful slides is that patients can bring their medication into healthcare facilities if those facilities allow it. So if a patient is hospitalized or in hospice care, the rule change allows them to bring it in. Now we have healthcare systems that are saying absolutely not.
Alina Health being one of them.
Yeah, so that's kind of a mixed bag right now. That came out about a week ago.
Well, there was that one lawsuit, was it Colorado, where the employer tested that he was taking medical marijuana, they tested him, he was fired.
We have protections for that, so I'm glad that you brought that up. Actually, that's the very next part of the slide. In a lot of these cases, there was a decent amount of foresight in the initial bills that were put into the State House and State Senate versions of this law, one of which did actually address that issue, which is patient protection. Now, this obviously doesn't necessarily cover use or impairment at work, but you can't be precluded from employment or fired from your job because you're in this program. It's not allowed. How they're going to navigate that with patients who use cannabis and there's not really good impairment testing, it can stay in your system up to, both of non-active metabolites can stay in your system up to a month for some people. I'm not entirely sure how they're going to do that. Aside from that, of course, if you happen to use cannabis at all right now, recreationally, medically, personal use, religious use, whatever, there are a lot of municipal statutes that will direct the county, if the landlord doesn't evict you, to turn the eviction over to the landlord. So people get booted on Section 8 housing, child custody, and things like that as well. So those are protected under this current law, necessary medical care and custody or visitation rights. So for those of you that practice that practice and have lawyers that are in the family law areas, like I will be, you'll probably see these types of things happen. Oh no, she's in the cannabis program, she's using cannabis, and I should have my children away from her. That's not going to fly anymore unless they're not in the program and they have maybe just cancer light or something like that, not like full blown. Oh my God, I have a year left cancer. So the protections are there. The other protection that was thankfully written to the state statute was a protection for lawyers to advise their clients how to navigate this. So by state statute, thankfully I'm up here and I'm able to talk about the subject without breaching professional responsibility and advising people to follow what is against federal law. Now, of course, that doesn't cut it because there's not enough red tape for me to cut through. I've got to, of course, go through the board of professional responsibility. A lot of the worry that I had was, I know a lot about this area of the law, I'm very well versed in it, what about my license? Because it doesn't matter if I happen to be able to go out and tell a patient or somebody who's coming into my office maybe looking to set up a business for this, that I'm protected by statute. When the statute's not actually keeping my license intact, that's the board of professional responsibility. So we were looking for somebody to get an advisory opinion out of them that was actually positive. And thankfully in April of 2015, we did have an advisory opinion come out that just says the lawyer can advise a client about the Minnesota medical law, represent and assist compliance and things of that nature. So I'm already well versed in that sort of thing. I now have protection from the board of professional responsibility when I'm launching my law firm this month.
And so that's so long as you also advise the client that what they're doing is illegal under federal law.
That's correct too.
That's kind of an important component there, right?
No, practice schmack this. No, that's not a thing you say. It's on the bottom of my business cards. No. So that takes care of the Controlled Substance Act issue. There, and just as kind of a dovetail back to the very beginning, we did mention that intractable pain is up for review, so that might expand this quite substantially, and also the fact that this is illegal on a federal level. However, there is an act in Congress right now called the CARES Act, and there was recent testimony, hours of it worth, given before the Senate. It's phenomenal. I mean, my geek brain just loves it. But this may change at a federal level very quickly. So
In a good way or a bad way?
In a good way.
in a good way for patients, depending on the side of the aisle, whether you think this is going to injure a lot of people or not. It might be a bad way if you happen to be, born in the 1800s.
No, if you were born in the 1800s, you were going to the local pharmacist and saying, here's what I need.
Tinctures.
That's true, that's true.
We don't have a whole lot. I think that's pretty much all that we have right now. We'll be continuing to put all of this information up. We have it available on sensible.mn, so if you have questions about that, I've got my card. You can call myself. Maren also has her cards. You can call her, email either one of us, or go to our website if you have any questions about how to help your patients or clients that come into the office navigate this law, and what the interplay is going to be with other state laws that happen to coincide with it, because there are going to be a lot of questions as this expands. As of right now, like Maren said, only 41 people enrolled, but with the addition of intractable pain and a lot of movement on the federal level, this is going to develop really fast, like next year fast. So be prepared for a lot of changes and possibly more manufacturers.
One question.
Yeah.
This is only looking at like extracting substances from the marijuana plant itself and playing with it and adjusting it. Why hasn't the state, since it's the plant as it is, it might be an interaction with both, why aren't they looking at that as a medical use?
So whole plant, basically.
Yeah.
It's much less expensive. The answer is basically two-part. One, the MPPOAA, the Minnesota Police Officers Association, and I threw in a couple extra O's in there. They lobbied heavily to not have whole plant. They didn't want anything to do with it. They tried to shut that down. It's much less expensive. If any of you are really interested in the science behind this, you can go on to YouTube and Google Dr. Sanjay Gupta of CNN. He addresses all of that, basically. But the idea is that the state legislature does not want to touch it because there are law enforcement considerations and treatment facilities and things like that that have very heavy lobbying power down at the Capitol. Hazelton is right in Minnesota too, so they have a lot of say in what happens and what does not happen, and they do see this as a highly addictive, dangerous substance. So there'll be some fights coming up in the legislature over that, I'm sure, next year again.
Any other
There's a really good article in National Geographic this month about.
Nat Geo, Time Magazine,
Yeah.
and the American Legion magazine all had articles this month.
Yeah.
So this is like probably, besides the Supreme Court's ruling today on same-sex marriage, this is probably like the most relevant issue across the board throughout the country.
Yeah.
So Google cannabis news, you're gonna find tons of it.
One thing we failed to mention too, which is something that's basically part of the patient advocacy program that Maren is developing right now through her experiences, is that we do have a patient group online. They're accessible if you know people that want to get help or talk to other patients or the caregivers, and they know people in their family that want to be able to help them. A lot of dealing with this is going to be dealt with ground level, not with our nonprofit, because we just don't have the hands to deal with it. But the thing is, we do have a large patient group online on Facebook right now, and they're sharing their stories and experiences as they work through the system. So feel free to direct people to that as well if you're interested. It just takes a little click button to get there.
What do you think the odds are that Minnesota will become less restrictive and more open? And not just medical, like
Recreation.
recreational.
Do you want me to answer that?
Sure, I'm super positive.
Yeah, we have 5 states, or 4 states in DC now with legal recreational. There's 2 ways to get that through. In the 4 states in DC, it was done by ballot initiative, meaning people went out, collected, 50,000 signatures saying we want this on the ballot, and it was voted on by the people. Minnesota doesn't have that process. We have a strictly legislative process, so even if we want a constitutional amendment and a ballot question, the legislature has to put it there. So we're likely going to be behind.
Yes, we're 37th to repeal alcohol prohibition.
Yeah, so, to a certain extent, it's inevitable. In my opinion, it's inevitable. It's going to happen one way or another, but we're probably going to be far behind the pack in that.
And also keep in mind, when this law was passed, there was, I think, a public approval rating of 68% in favor of medical cannabis.
Which
So
is now up to 76 in the last
even
poll.
with that, and we get these sorts of restrictions out of our representatives. So there'll be a lot of tinkering, and by golly, I know a lot of people in the activist movement will be pressing very, very hard to get expansion of this law, especially when people go and say, hey, I've heard this is really good for this ailment. Oh, what do you mean I can't get it? I know a little boy who has a disease right now, and he doesn't qualify, and he's got severe nausea, and he's hospitalized very often. And he asked his mom why he couldn't have one of the other diseases. So there are a lot of people that will be pressuring very, very, very hard on the state government to get those sorts of things taken care of and passed. So I think that there'll be a decent amount of expansion in the future. But if you have any more questions, feel free, like I said, to email us. We've got our cards up here, or check out our website. We're really glad that all of you showed up, and I'm glad to be here because it didn't have to be a week. So. It is exactly 2 o'clock.